Appeals and final judgment rule. Appellate courts and standard of review. Review potential errors on questions of law, highly deferential to the questions of fact. A question of law is an appellate court can substitute its judgment for that of a trial judge. With questions of fact, it will not be disturbed unless a non-jury decision, such as a bench trial, clearly erroneous. Jury trials, reasonable jury could not have reached the same conclusion. Mixed questions, questions of law and fact, de novo. Discretionary matters are evidentiary rulings, abuse of discretion. Final judgment rule. Appeals may only be taken from a final judgment, meaning trial has made an ultimate decision on the merits of the entire case, otherwise appellate court lacks jurisdiction. Exceptions are that these orders are appealable without final judgment. Injunctions are entitled to interlocutory appeal. A certification of class actions may be appealed. Orders involving debatable questions of controlling law, multiple claims and/or parties, a trial may enter a final judgment as to one or more party and/or claim, which is then appealable. Timing. Must file notice of appeal in trial court within 30 days of entry of final judgment. Interlocutory appeals and extraordinary writs. Though generally only final orders are appealable, some interim interlocutory orders may be appealed before final judgment. Interlocutory orders reviewable as of right. 1. Injunctions, orders concerning an injunction. 2. Receivers, orders concerning appointment of receivers. 3. Patent orders where only accounting is left in the case. And 4. Property orders affecting property such as attachment. Interlocutory Appeals Act. Appellate court may hear appeals of a non-final order if trial judge certifies that the order involves a controlling issue of law with substantial grounds for difference of opinion. Class action. Appellate court may review an order granting or denying class certification. Collateral order exception. Appellate court may hear an interlocutory appeal on an issue if it is 1. Too distinct from the merits of the case, collateral. 2. Too important to be not denied review. And 3. Would essentially be unreviewable if parties waive for final judgment. Extraordinary writ. A party aggrieved by an unappealable order may seek a writ to compel or prohibit lower court action, must show irreparable harm will occur, and normal route of appeal is inadequate. Claim preclusion. A party has an opportunity to litigate a claim, cannot relitigate a claim once final judgment has been rendered. Claim preclusion is an affirmative defense. Requirements are that new claim will be precluded if 1. They're the same parties. The second case was brought by the same party against the same parties, so the same plaintiff, same defendant, and entity in privity with a party is considered the same party. So, for example, an employee and employer are the same party for claim preclusion purposes. 2, we got the same claim in the first and subsequent suit. Claim refers to the transaction or series of transactions or occurrences giving rise to the action. Even if not previously raised, claim can be precluded if it is sufficiently related to prior claims. 3. Final judgment on the merits in original claim. Judgment is final even if it is being appealed. Dismissal with prejudice operates as a judgment on the merits. Technical dismissals, subject matter jurisdiction, personal jurisdiction, venue are not on the merits because they are not evaluating the substance of the plaintiff's claim. Issue preclusion, collateral estoppel, prevents relitigation of particular issues of fact or law that have actually litigated and previously determined. Narrower than claim preclusion, it does not preclude the whole claim necessarily, just the same issue. Issue must have actually litigated. So this is distinguished from claim preclusion, which only requires an opportunity to litigate. The requirements are: 1, final judgment on the merits. First case ended with a valid final judgment on the merits. 2, same issue. So the same issue was actually litigated and determined in the first case. 3, issue was essential to the judgment. Judgment would have been different in the first case. Absent litigation of this issue, must be clear how the issue was decided by the original trier of fact. And 4, asserted against the actual party to a previous case. Who may assert issue preclusion? 2 views: mutuality, traditional view. Only parties to prior litigation can assert issue preclusion, and non-mutuality, modern view. Issue preclusion may be asserted by those who are not parties in the prior litigation. Issue preclusion, offensive and defensive use of prior judgment. Non-mutual issue preclusion may be used defensively or offensively, although courts are reluctant to allow offensive use. Defensive use of prior judgment. Defendant seeks to prevent plaintiff from relitigating an issue plaintiff lost in a prior suit against a different party. This is allowed if the party against whom the preclusion is asserted had a full chance to litigate the issue previously. So, for example, defendant in second case can preclude plaintiff from relitigating an issue plaintiff lost to defendant in a prior case. This is non-mutual because the party asserts plaintiff asserting IP was not a party in the prior litigation. Offensive use to prior judgment. Plaintiff seeks to prevent defendant from relitigating an issue that defendant previously lost in a prior suit against a different party. Highly disfavored and rarely allowed. Courts will allow only if deemed fair after balancing factors. Factors are: 1, whether a party against whom prior judgment is asserted had full and fair opportunity to litigate. 2, whether party could foresee multiple suits being filed. 3, whether party asserting an initial plaintiff controlled or could have joined prior litigation. And 4, there are no inconsistent judgments on the record.